You guys ready for some evidence? Yeah. Here's the other thing I think you need to be doing between now and the time the problem comes out. Because this is where the teams shine. Those foundational issues and the evidence. And the evidence is hard. So I'm just going to say that out front, or up front, that evidence is hard. It requires you to spend a fair amount of time studying some really... Judy, do you need some help? You want me to give out more prizes?
Always.
Okay. Well, I'll give out some after evidence, because I'm going to have some evidence superstars in the room, I'm pretty sure. Yeah. I'm pretty sure. So you have to decide, when we talk, let's talk about objections generally, before we talk about specific evidentiary issues. You have to decide when to object. Okay? And this is where it requires a little bit of skill. There are times when someone may be admitting something and you decide not to object. Why would you do that? That's a good one, Quinn. I think, Judy, you can give out. Why can't we give out prizes during? Quinn gave it. All right. What about in the back? What other reason might you have? Okay. Well, anyone think of any other reason? Yes, in the back. I'm sorry. What?
Can't hear some of the answers.
Okay. Okay, yes, the answer on why you may not object to evidence that would be coming in, even though there's an evidentiary violation, the answer here in the front was that you may not object because you want it in. Okay. Oh, Casey, that's absolutely. You may not object because it's not vital or it's not important. If it's about what color the sky was and the color of the sky is completely irrelevant, then you may not object in that particular point in time. All right, so that's when to object. Obviously, you're going to object on anything that you want to, or if there is a proposed violation or it appears to be a violation, you're going to object before it gets in, right? You're not going to sit there and wait and go, let me see, is this an objection? Meanwhile, the witness has testified, it's in, the jury has heard it. So you're going to want to object as soon as the question is asked. There are other times that you object, and you've got to have something that sounds legitimate come out of your mouth with the objection, but it's to interrupt the flow of the other side. Okay, it's got to be legit. But it might be moving a little bit closer to the side of a strategic objection. If your witness and if your witness is being cross-examined, the other side's just keep going. If you can think of a legitimate basis for the objection, then you need to stand on your feet and make the objection, if for no other reason but to stop and give your witness a chance to gather his or her thoughts and move forward. Okay, so who objects? We've talked about who has to object. It's limited to the attorney who's going to do the examination. Now, is it only during, would you only be objecting during the opposing party's presentation? Anyone think of a time? It could be. Can you think of a time when you might object to your own witness? Yes. You might object if your witness is being non-responsive. Judy. Yes. Yeah, but that would be during the other party doing the questioning. I'm trying to think of the scenario when you're questioning your witness.
If the witness breaks from their witness statements?
Okay, you're not going to object if your witness breaks from the witness statement. You're going to actually impeach your own witness, which is really not fun. But sometimes you have to do that. Yes, sir? You absolutely, the rules do not permit you to object during closing argument, but you can, if there was an objection, something objectionable about the other party's closing, you can raise the issue at closing or after closing and said, had I been offered the opportunity to object, I would have objected on the following grounds. Yes, sir. If asked what? If the other side is asking, yes. Those are scenarios when we might be objecting to the other side. I'm still just trying to, the question really was centered on when you're going to object to your own witness. I think we've covered, yes. What's that? If you have a hostile witness, you absolutely would be, could be objecting during their testimony. Okay. So the rules of competition, one of the things we did not necessarily address specifically there, but I'll just incorporate by reference, but the rules of competition talk actually about objections. And they talk, and what the rules of competition say is that when you object, you have to be able to articulate the basis for your objection. Okay? So generally what that means is that if you stand up and you object, your first thing you're going to say is objection. And then you're going to, depending on whether it's a form objection or evidentiary objection, so I'm going to distinguish between that. So if it's a form objection and it's asked and answered, for instance, that's an objection to the form, I'm going to say objection, asked and answered. So I'm going to articulate the basis for my objection. And then if I have something I want to argue, I'm only going to get, each side's only going to get 2 opportunities, at least that's what we've told the judges to do, to argue each side. So if I have an argument there, I might present a very brief argument. If it's asked and answered, you can say, you know, counsel has asked this particular exact question 3 previous times, and the a witness has provided an answer. If you are objecting based on a rule of evidence, you are going to say objection pursuant to rule blah, blah, blah. You know, this question calls for irrelevant information, or, you know, the question calls for hearsay. So you're going to give that brief explanation and specifically cite the particular rule. So we're going to talk briefly about common objections and where you might find some of those objections in your rules of evidence. Before we talk about specific rules of evidence, I will refer you to one of the other changes that was made in 2012 to the rules of competition. Under sections 2E, 4, there are a list of common form objections you might make. These are to the form, that's exhibits. Let me get to the right page. Sorry, it's H, yes, 4H. There are examples of objections and what the basis of those objections. So you can see there, argumentative, lack of proper predicate or foundation, questions calling for a narrative. Note that this section was added to track what the national rules are. These are part of the national rules. So if you have your sights set high and going to nationals, this will prepare you to know these particular objections and when to raise them. Most of these objections, by the way, are all, if you want to be really fancy pants, are all founded in Rule 611 in the various subparts. So if you want to look through Rule 611, which is not a very commonly cited rule, Rule 611 really has to do with how information is presented to the court. But if you read the rule, you can see that the presentation of material is to, for instance, avoid needless consumption of time. So not very many people are necessarily citing Rule 611, but if, again, you want to be fancy pants, you can know exactly where that rule has been inferred from. The other one, for lack of proper foundation, actually comes from Rule 104B. Okay, so we'll talk about the most common evidentiary-based objections. So one is you have to have a competent witness, right? The first thing, you got to get someone on the stand who knows something about it. They either have personal knowledge, and if they don't, they have to be testifying as an expert. There's really no other basis to have someone up there. So personal knowledge, if they do not have personal knowledge and they're not an expert, personal knowledge is covered in Rule 602. The expert witness rules are covered in 702. So you have a personal knowledge, assume you have that. Then you have to make sure what they're saying is actually relevant. It's kind of good. So what does it mean to have relevant? What does relevance mean? Yes, sir. Right. What is it? And how, to answer that, Judy will give you a prize. I'll remind her. To answer that, you have to actually know what it is that you're trying to prove. So it's not just actually pertaining to the case. It's really actually the leather jacket there, or appears to be. So you actually have to know what you're trying to prove. If you never read those jury instructions, as Jennifer was talking about, you aren't going to know what you have to prove. A lawyer, a good lawyer, will start with the jury instructions and work from there. You will always know what it is that you are trying to prove. And when you go through every witness statement and every exhibit, you will mark, how will this help me prove or disprove prove my case or disprove the other side? And which element is it proving? Because if you know that, if you get a relevancy objection, you're going to know exactly. You might even make notes or make charts relative to those witnesses' statements or that particular exhibit. So if I make a relevancy objection to your introduction, say, of a piece of evidence, you're going to have right here in your notes, oh, I need to, that's relevant to show X. So it has to be relevant. The rules for relevancy, and Rule 402 says that if it's relevant, it's admissible. The default rule is admissibility. On the opposite is, if it's not relevant, it's not admissible. So Rule 402 can be important. Note that 402 is the rule for admissibility. 401 is the definition. Sometimes I see people, it's not admissible under Rule 401. No, it's not relevant under 401 because 401 is the definition. It's not admissible under 402. Okay, so most relevant information is admissible, we know, under Rule 402, but there are some circumstances when it will not be. Those exceptions you'll see in 403 and 404, for example. I won't hit those specifically, but note that those are sort of carve-outs to otherwise relevant information. So the other really big, and this is the one that I think gets most people, is understanding what hearsay is. Okay, someone give me what you think hearsay is. Yes, ma'am. When a person testifies about what another person said. Can hearsay, that's correct, that is an example of hearsay. Can hearsay, what if you're testifying about what you said at another time? Is that hearsay? Yes, sir. Actually, it is. Any out-of-court statement, whether it's you saying it or someone else saying it, is actually, in fact, by definition, hearsay. Now, there are carve-outs, but as a general rule, that would be hearsay. So let me talk about carve-outs because that's generally where you end up with some confusion. So if you made a prior statement, and that prior statement, for instance, was made under oath, so maybe your witness statement, then that statement would not be hearsay. So that's 801D1. If I am examining, if someone else's witness, or there's a statement being offered against me, so maybe it's usually the other side's witness, and they're being offered, and I'm the defendant, and they're saying something about what I said, then that is going to be an admission. That's a statement I made. I'm a party opponent. So that's going to be excluded under 801D2. There are a host of... What? Or that's going to be excluded from the definition, thank you. Wrong terminal. Excluded from the definition of hearsay. Doesn't necessarily mean it will be admitted, thank you. There is the rule that prohibits admission of hearsay is 802, much like it was 402 for relevance. And there are a host of exceptions to the hearsay rule. Someone give me an example of an exception to the hearsay rule. Yes, sir. Okay, tell me give me an example of what an excited utterance might be like. What might happen?
Say you were in like a really like extreme situation and you just started like yelling like in the key of the moment, like, "Oh, I'm gonna kill you."
Right. I'm in some really excited thing. Maybe I got in a car accident and someone rear-ended me, and I go back and I just like, I'm going to kill you for that. Absolutely would be an excited utterance. How about give me another example of another type of hearsay exception? Yes, sir. Oh, ma'am, sorry. Yes. A person is dead. Well, let me tell you about, there is under Rule 804 an opportunity for some statements to be admitted as non-hearsay or excluded as non-hearsay if the declarant is unavailable, which they can be obviously if they're dead, and it fits one of the exceptions. But just being dead in and of itself does not get the statement in. Okay, some other examples. Yes? Give me an example of what that would be like.
Like, if someone was there at the time of the incident and they were there to like witness it happen, they would have the presence of suppression.
If they made the statement while they were perceiving what happened, they can't be later making the statement, but if they were making the statement while they were watching it, that would be correct. Yes, sir. Yes, history for medical diagnosis. Theory is if you go to your doctor, you're going to be truthful with your doctor about what your symptoms are. That being said, if you say, I'm suffering from this big gash in my leg because my brother took an axe to it, the statement about your brother taking an axe to it is not necessarily going to be admitted under 803.4. Yes, sir. Okay, give me an example of a public record or report that would be admissible under 803.8. A schedule. Right. If you worked at a grocery store and they published a schedule, well, it wouldn't be a public record then, so that wouldn't be. Maybe a record of a hearing or something might be a public record. Yes, ma'am? If it were a private company and they regularly published a schedule, it would be 803.6, yes. Okay, yes, sir.
Part 21, reputation as a character, like if a student was accused of murdering their mother years ago, and because that came out,
Reputation as to character, you're right, is an exception 803.21. As you can see, there are a lot of exceptions to the hearsay rule. It is probably the most helpful thing for you all if you actually look at these rules and try and think of examples, because that will make it a little bit more relevant to you all and you'll be more comfortable raising it. You want me to ask questions? Or oh, yeah, tell you about these. Yeah.
Okay, so on the website very soon, we're going to have kind of a mock trial objection cheat sheet. And it's a one-page list of kind of all of the most common objections and the rule number that you would cite when giving that objection. And this is a tool that you can use to try and quickly remember, okay, I'm trying to think in the moment, and this would be the rule that I would cite, because you get an extra point for, citing the correct rule number and raising a proper objection. So hopefully this will be a helpful tool as you go through the competition this year that we haven't had in the past. In addition, we will also be posting a hearsay checklist. And this kind of gives you something that you can start to process through when you might want to make an objection on the grounds of hearsay. And it also gives you a quick cheat list kind of scenario for a lot of the exceptions. There's present sense, excited utterance, and all the rule numbers are given with the subparts for each one of those. So you can keep these at your conference table as you're presenting your trial, and hopefully that will help everybody to get the objections out there in the proper time and the proper objections. Yeah.
She's going to ask a couple more questions before we take a break. I want to tell you one other thing about hearsay is watch for hearsay in documents. Okay? Just because you think about it more when witnesses are saying so-and-so said such and such, but it's in documents. Documents can be hearsay as well. So, okay.